in this one we are continuing the things from this part, that is the evaluation of threat. This is our second video relating to the professional ethics and liability of auditor. Before we have covered the things, इससे पहले की सारी चीजें we have covered. Now we are proceeding with the evaluation of threats. So what is basically the evaluation of threat? क्या जो condition है, policy है, procedures है, हम क्या बोलते हैं कि जो conditions है, policies है, procedure जो भी describe है above might impact the evaluation of whether the threat to compliance with the fundamental principle is at an acceptable level. Acceptable level क्या होता है? What is acceptable level? Basically an acceptable level is a level, वो level at which the professional accountant using the reasonable, हम क्या बोलते हैं that what is the acceptable level? An acceptable level is a level at which the professional accountant using the reasonable and informed third party test would likely to conclude that the accountant complies with the fundamental principle. What will be the reasonable and informed third party? The reasonable informed third party test is the consideration by professional accountant about whether the same conclusion would likely to be reached by another party. Such a consideration is made from the perspective of reasonable and informed third party who weighs all the relevant facts and circumstances that the accountant knows and could reasonably be expected to know at the time the conclusion are made. The reasonable and informed third party does not need to be an accountable but would possess the relevant knowledge and experience to understand and evaluate the appropriateness of accountant's conclusion in an impartial manner. Addressing threat. How will you address the threat? If the professional accountant determines that the identified threat to compliance with the fundamental principle are not at an acceptable level, the accountant shall address the threat by eliminating them or reducing them to an acceptable level. The accountant shall do so by eliminating the circumstances, including the interest or relationship that are creating the threats, applying the safeguards wherever available and capable of being applied to reduce the threat to an acceptable level, and declining or ending the specific professional activity. What are the action to eliminate the threat? कौन से action होते हैं जिससे हम eliminate कर सकते हैं threat? Depending on the facts and circumstance, a threat might be addressed by eliminating the circumstances creating the threat. However, there are some situations in which threat can only be addressed by declining or ending the specific professional activity. This is because the circumstances that created the threat cannot be eliminated and safeguards are not capable of being applied to reduce the threat to an acceptable level. What are the safeguards? Safeguards are action individually or in combination that the accountant takes that effectively reduce threat to an acceptable level. Safeguards vary depending on the facts and circumstances. What are the examples of action that in certain circumstances might be safeguard to address the threats? Include assigning additional time and qualified personnel to require the task where an engagement has been accepted might address a self-interest threat. Having an appropriate reviewer who was not a member of the team review the work, perform, or advise as necessary might address the self-review threat. Using different partners and engagement team with separate reporting lines for the provision of known assurance service to an assurance client might address self-review, advocacy of or familiarity threat. Involving another firm to perform or re-perform the part of engagement might address the self-interest, self-review, advocacy, familiarity, or intimidation threat. Separating teams when dealing with matters of a confidential nature might address the self-interest threat. तो अब आ जाता है हमारा NOCLAR. NOCLAR is a very important topic. If you know, then that is basically what is the known compliance with laws and regulations. How will you read this chapter, that is NOCLAR topic? This I heard from many people that NOCLAR is important and all. I don't know so much about this, but I think this is important and we are reading with just that thought. So what is a known compliance with laws and regulation? कैसे known compliance होगा? How there will be the known compliance? हम क्या बोलते हैं that how there will be the known compliance कैसे होगा with the laws and regulation? NOCLAR is nothing but the known compliance of the law. NOCLAR is what? NOCLAR is nothing but the known compliance. NOCLAR is nothing but the known compliance with laws and regulation. In the course of providing a professional service to a client or carrying out professional activity for an employer, a professional accountant may come across an instance of non-compliance with laws and regulation or suspected NOCLAR committed or about to be committed by the client or the employer, or by those charged with governance, management, or employee of the client or employer. Non-compliance with laws and regulation. Non-compliance comprises of act of omission, commission, intentional, unintentional, which are contrary to the prevailing laws and regulation, which is committed by the client, professional accountant, employing organization, those charged with governance of a client or employing organization, management of a client employing organization, or other individual working for or under the direction of a client employing organization. However, no CLAR under the revised Code of Ethics does not address the personal misconduct unrelated to the business activity of the client employing organization and non-compliance by parties other than listed out in the definition of no CLAR. As per the ISBA, following example would be covered in no CLAR: fraud, corruption and bribery, money laundering, terrorist financing and proceeds of crime, security market and trading, banking and other financial product and services, data protection, environmental protection, public health and safety, tax and pension liability and payments. The objective of no CLAR is that running a blind eye to potential no CLAR is not an appropriate response from professional accountant while placing renewed emphasis on the rules of management and those charged with governance in addressing the matter. Further, it increases the awareness and understanding among the professional accountant of their legal and regulatory responsibilities when they face a no CLAR. Some important facts about no CLAR are given below. During the course of providing a service, no CLAR will be applicable if a professional accountant encounters or is made aware of a known compliance or suspected known compliance in the course of providing a professional service to a client. He is not required to investigate nor responsible for ensuring complete compliance. Expertise of law not required. A professional accountant is expected to apply the knowledge and expertise and exercise professional judgment. However, he is not expected to have a level of knowledge of laws and regulation greater than that which is required to undertake the engagement. Whether an act constitutes non-compliance is ultimately a matter to be determined by the court or other appropriate adjudicative body. Certain matter expressly out of purview, matter that are clearly consequential or relating to personal misconduct pertaining to business activity of the client not covered. Disclosure which is contrary to law not required as per the IESBA code. Disclosure of a matter to an appropriate authority would be precluded if doing so would be contrary to the law and regulation. Applicability of no CLAR in India. Responding to non-compliance with laws and regulation applicable to professional accountant in service, section 260 applicable to senior professional accountant in service being employee of listed entity. Senior professional accountant in service. Senior professional accountant are directors, officer or senior employees able to exert a significant influence over and make decisions regarding the acquisition, deployment and control of employing organizations, human, financial, technological, physical and tangible resources. It is further explained that the senior professional accountant refer to key managerial personnel. Responding to non-compliance with laws and regulation, no CLAR applicable to professional accountant in public practice, section 316. Applicable to audit engagement of entities, the shares of which are listed on recognized stock exchange in India and have a net worth of 250 crores rupee or more. For the purpose of Section 360, audit or audit engagement shall mean a reasonable assurance engagement in which a professional accountant in public practice expresses an opinion whether the financial statement gives a true and fair view in accordance with applicable financial reporting framework. No CLAR versus SA 250. SA 250 is applicable only on audit and not on other assurance engagement. However, no CLAR is applicable on professional accountant in service and in practice. SA 250 talks of auditors' responsibility for law having the direct effect on the determination of material amount and disclosure in the financial statement, such as tax and labor laws and other laws and regulations that do not have a direct effect on the determination of amount and disclosure in the financial statement, but compliance which may be fundamental to the operating aspects of a business. No CLAR, while being alike to SA 250, still this point is further ahead of it in that it takes into account non-compliance that causes the substantial harm resulting in serious consequences in financial or non-financial terms. ऐसे 250 does not define a stakeholder. No CLAR is related to effect of non-compliance on investor, creditor, employee and are also the general public. As per no CLAR, in exceptional circumstances, the professional accountant might become aware of imminent breach of law or regulation that would cause substantial harm to investor, creditors, employees of the general public, having first considered whether it would be appropriate to discuss the matter with management or those charged with governance of the company. The accountant shall exercise professional judgment and determine whether to disclose the matter immediately to an appropriate authority in order to prevent or mitigate the consequences of such imminent breach. If disclosure is made that disclosure is permitted, this provision is non-existent in SA 250. Applicability of no clar in India responding to no clar in case of employment, in case of audit engagement, and steps to be taken for responding. Responsibility of senior professional accountant in a service. Responsibility of professional accountant other than senior professional accountant. Responsibility of professional accountant obtaining an understanding of the matter, addressing the matter, seeking advice, determining whether further action is needed, determining whether the disclosure the matter to an appropriate authority, imminent breach, and documentation. It may also be noted that in a situation where disclosure ought to be made by the auditor, the appropriate authority for the purpose of disclosure will depend on the nature of the matter. For example, the appropriate authority would be SEBI in case of fraudulent financial reporting. Appropriate alignment has been made in the code with regard to requirement of confidentiality as required under the Chartered Accountant Act 1949. Provision of confidentiality under Chartered Accountant Act 1949 for members and a practice clause 1 of part 1 of second schedule to the Chartered Accountant Act 1949. A chartered accountant in practice shall be deemed to be guilty of professional misconduct if he discloses information acquired in the course of his professional engagement to any person other than his client, so engaging him without the consent of his client or otherwise than as required by the law for the time being in force. Then comes for members in service, that is clause 2 of part 2, the second schedule of the Chartered Accountant Act 1949. A member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he is being an employee of any company, firm, or person discloses confidential information which is acquired in the course of his employment, except as and when required by any law for the timing in force or except as permitted by the employer. Documentation requirement in no clarity, a revised code over and above require the professional accountant to follow the additional document requirement as under. How management, those tasked with governance, has responded to the matter, the course of action of accountant, consider the judgment made and the decision that were taken having regard to the reasonable and informed third party test. How the accountant is satisfied that the responsibility of public interest has been fulfilled. This documentation is in addition to complying with the documentation requirement under the applicable auditing standards. SAs, for example, require a professional accountant performing an audit of financial statement to prepare documentation sufficient to enable an understanding of significant matter which is arising during the audit. The conclusion reached and the significant professional judgment made in reaching those conclusions. Document discussion of significant matter with management, those tasked with governance, and the other including the nature of significant matter discussed and when and with whom the discussion took place. And document identify or suspected non-compliance and the result of discussion with management and where applicable those tasked with governance and other party outside the entity. Membership of the institute. On acceptance of application by the council, the applicant's name shall be entered in the register and a certificate of membership in the appropriate form shall be issued to the applicant. Particulars of the register. Section 19 of the Chartered Accounting Act 1949 provides the particular to be included in the register about every member of the institute, namely full name, date of birth, domicile, residential and professional address, date of entry of name in the register, qualifications, whether the member holds a COP and any other prescribed particulars. Disability for the purpose of membership. Section 8 of the Chartered Accountant Act 1949 enumerates the circumstances under which a person is debarred from having his name entered in or body on the register of member as follows. If he has not attained the age of 21 years at the time of his application for the entry of his name in the register of members, or he is of a unsound mind and stands so adjudged by a competent court, and he is undischarged insolvent, or he is being discharged insolvent or has not obtained from the court a certificate stating that his insolvency was caused by misfortune without any misconduct on his part, he has been convicted by competent court whether within or without India of an offence involving moral turpitude and punishable with imprisonment for an offence not of technical nature committed by him in his professional capacity, unless in respect of offence committed he has either been granted a pardon or on application made by him in his behalf, the central government has, by an order in writing, removed the disability, or if he has been removed from the membership of the institute and been found on inquiry to have been guilty of professional or other misconduct. It may be noted that a person who has been removed from membership for a specified period shall not be entitled to have his name registered in the entered in the registered until the expiry of such period. In addition, failure on the part of a person to disclose the fact that he suffers from any of the disability aforementioned would constitute professional misconduct. The name of the person who is found to have been subject at any time of the disability aforementioned can be removed from the register of member by the council. Types of members of the institute. Section 5 of the Chartered Accountant Act 1949 provides the division of members of the institute. The members shall be divided into two classes, designated or associate and fellows. Designated as the members are classified into two types, that is associate and fellows. Associate member, any person whose name has been entered in the register of members shall be deemed to have become an associate of the institute and shall also be entitled to use the letter ACS after his name to indicate that he is an associate of the institute. Associate member as a fresher. Fellow member, the name of the following types of members shall be entered into the register of member as a fellow of the institute on a payment of such a fee along with the application made and granted in the prescribed manner. An associate member who has been in a continuous practice in India for at least, अगर कोई associate member अगर practice में है in India for at least 5 years, a member who has been associate for a continuous period of not less than 5 years and who possesses such a qualification as may be prescribed by the council with a view to ensuring that he has experience equivalent to the experience normally acquired as a result of continuous practice for a period of 5 years as a chartered accountant. The above mentioned member shall be entitled to use the letter FC after his name to indicate that he is a fellow member of the institute. Removal of name from the register. As per section 20 of the Act, the council may remove from the register the name of any member of the institute in the following cases: who is a dead, अगर वो मर चुका है, from whom a request has been received to that effect, who has not paid any prescribed fee required to be paid by him, who is found to have been subject at the time when his name was entered in the register of member, or who at any time thereafter he has become subject to any of the disability mentioned in section 8, or who for any other reason has ceased to be entitled to have the name bonding on the register. The council shall remove the name of any member from the register in respect of whom an order has been passed under this act removing him from membership of the institute. If the name of any member has been removed from the register for non-payment of prescribed fee as required to be paid by him, then on receipt of such application his name may be entered again in the register of member on payment of the arrears of annual fee and entrance in fee involving such additional fee as may be prescribed by the council. Restoration of membership. In addition to the provision of Section 20 of the Chartered Accountant Act 1949 as discussed in above paras, Regulation 19 of the Chartered Accountant Regulation 1988 states that the name of the member may be restored by the council in the registrar on an application if the appropriate form received in this behalf whose name has been removed from the register for non-payment of prescribed fee as required to be paid by him. If he is otherwise eligible to such a membership on his paying the arrears of annual membership fee, entrance fee and additional fee determined by the council under the act. However, the effective date in case of restoration of cancelled membership in different situations shall be in the following manner. Application for restoration and requisite fees are made within the same year of removal. The restoration shall be with effect from the date on which it was removed from the register. तो उसी डेट से हो जाएगी जिस डेट से कैंसिल हुई थी उसी डेट से रिस्टोर हो जाएगी. Removal of name under the order of the board of discipline or disciplinary committee or appellate authority or the high court. Restoration shall be in accordance with, अगर किसी ऑर्डर की वजह से रिमूव हो रहा है तो वो ऑर्डर के अकॉर्डिंग ही होगी. और अदर केसेस में restoration shall be with the effect from the date on which the application and fees are received. Otherwise अगर सेम ईयर में होती तो सेम डेट से हो जाएगी, और अगर जिस दिन से फीस आई उस दिन से हो जाएगी, और अगर कोई रिमूवल वगैरह है तो फिर ऑर्डर के हिसाब से होगी. पेनल्टी फॉर फॉल्सली क्लेमिंग टू बी मेंबर एक्सेट्रा. सेक्शन 24 ऑफ द चार्टर्ड अकाउंटेंट एक्ट 1949 प्रोवाइड दैट एनी पर्सन हु नॉट बीइंग अ मेंबर ऑफ द इंस्टीट्यूट represent that he is a member of the institute or uses the designation chartered accountant being a member of the institute but not having a certificate of practice, represent that he is in a practice or practices as a chartered accountant, shall be punishable on a first conviction with a fine which may extend to 1000 or any subsequent conviction with imprisonment which may extend to 6 months, or with a fine which may extend to 5000, or with both. The provision may be understood with a case where the court or additional chief judicial magistrate had by its judgment found the accused guilty under section 24 of the Chartered Accountant under Section 465 of Indian Penal Code, the court impose the fine on the accused, and in the event of failure to pay the fine, sentence to rigorous imprisonment for 3 months. Case of Prem Batra decided on this. Chartered accountant in practice of practicing chartered accountant is a person who is a member of the institute, is holding the certificate of practice, and includes such a member of the institute or deemed to be in practice in accordance with the provision of Chartered Accountant Act 1949. What will be the significance of certificate of practice? Section 6 of Chartered Accountant Act 1949 provides that no member of the institute shall be entitled to practice whether in India or elsewhere unless he has obtained from the council a certificate of practice. It may be noted that this provision is not applicable to any person who immediately before the commencement of this act has been in practice as a registered accountant or a holder of restricted certificate until 1 month has elapsed from the date of the first meeting of the council. Every such a member shall pay such annual fee for his certificate as may be determined by notification by the council, and such a fee shall be payable on or before the first day of April each year. The certificate of practice obtained under this section may be cancelled by the council under circumstances as may be prescribed. A member who is not in a practice is precluded from accepting engagement to render service of any of the type normally prescribed for a chartered accountant, even though for doing so he does not require special qualification. The Council of the Institute is of the view that once a person becomes a member of the Institute, he is bound by the provision of Chartered Accountant Act and its regulation. If and when he appears before the Income Tax Tribunal as the income tax representative after become a member of the institute, he could so appear only in his capacity as a chartered accountant, and a member of the institute having it were brought himself within the jurisdiction of the Chartered Accountant Act and a regulation. He could not set them at note by contending that even though he continued to be member of the institute and has been punished by suspension from practice as a member, he would be entitled in substance to practice in some other capacity. A member of the institute can have no other capacity in which he can take up such a practice separable from his capacity to practice as a member of the institute. Therefore, in a nutshell, a chartered accountant whose name has been removed from the membership for professional or other misconduct during such a period of removal will not appear before the various tax authority or other bodies before whom he could have appeared in his capacity as a member of this institute. A chartered accountant in practice has been suspended from practice for a period of 6 months, and he has surrendered his certificate of practice for the said period. During the said period of suspension, though the member did not undertake any audit assignment, he undertook representation assignment for income tax, whereby he could appear before the tax authority in his capacity as a chartered accountant. How we will cover such a thing, that is undertaking the representation work. Just hold. Am I audible? During the said period of suspension, though the member did not undertake any assignment, he undertook representation assignment for income tax, whereby he would appear before the tax authority in his capacity as a chartered accountant. Undertaking tax representation work, a chartered accountant not holding the certificate of practice cannot take up any other work because he would be violation of the relevant provision of the Chartered Accountant Act 1949. In case a member is suspended and is not holding the certificate of practice, he cannot in any other capacity take up any practice separable from his capacity to practice as a member of the institute. This is because once a person becomes a member of the institute, he is bound by the provision of the Chartered Accountant Act 1949 and its regulation. If he appears before the income tax authorities, he is only doing so in his capacity as a chartered accountant and a member of the institute, having bound himself by the said act and the regulation made thereunder. He cannot then set the regulation at a note by contending that even though he continues to be the member and has been punished by suspension, he would be entitled to practice in some other capacity. If he appears before the income tax authority, he is only doing so in his capacity as a chartered accountant and as a member of the institute. Having bound himself by the said act and its regulation made thereunder, he cannot then set the regulation at a note by contending that even though he continued to be member and has been punished by suspension, he would be entitled to practice in such some other capacity. Thus, in the instant case, a chartered accountant would not allow to represent before the income tax authority for the period he remains suspended. Accordingly, in the present case, he is guilty of professional misconduct. Then comes the cancellation and restoration of certificate of practice. Regulation 10 provides that a certificate of practice shall be liable for cancellation if the name of the holder of the certificate is removed from the register. The council is satisfied after giving an opportunity of being heard to the person concerned that such a certificate was issued on the basis of incorrect, misleading, or false information, or by mistake or inadvertence, or a member has ceased to practice, or a member has not paid annual fee for certificate or practice till 30th day of September of the relevant year. When a certificate of practice is cancelled, the holder shall surrender the same to the secretary. Further, Regulation 11 on restoration of CUP states that on application made in the approved form and on a payment of such a fee, the council may restore the COP with effect from the date on which it was cancelled to a member whose certificate has been cancelled due to non-payment of the annual fee for the COP and whose application complete in all respect together with the fee is received by the secretary before the expiry of the relevant year. Members deemed to be in practice, every member of the institute is entitled to designate himself as a chartered accountant. There are two classes of members, those who are in practice and those who are otherwise occupied. In section 2 2 subsection 2 of the act, the term deemed to be in practice has been defined as follows. A member of the institute shall be deemed to be in practice when individually or in partnership with the chartered accountant in practice or in partnership with the members of such other recognized professional as may be prescribed in he consideration or remuneration received or to be received, engages himself in the practice of accountancy or offers to perform service involving the auditing or verification of financing transaction, books, accounts of records of the preparation, verification or certification of financial accounting and related statement and hold himself out to the public as an accountant and render professional services or assistance in or about a matter of principle or detail relating to accounting procedure or the recording, presentation, or certification of financial facts or data. Render such other services as, in the opinion of the council, are or may be rendered by the chartered accountant in practice. And the word to be in practice with their grammatical variation and cognate expression shall be constituted accordingly. An associate or a fellow of the institute who is a salary employee of a chartered accountant in practice or a firm of such a chartered accountant or a firm consisting of one or more chartered accountant and a members of any other professional body having prescribed qualification shall, notwithstanding such employment, be deemed to be in practice for limited purpose of the training of the article assistant. Pursuant to section this above, the council has passed a resolution permitting a chartered accountant in practice to render entire range of management consultancy and other services. The expression management consultancy and other services shall not include the function of statutory or periodical audit, tax, both direct taxes and indirect taxes, representation or advices concerning the tax matter, or acting as a liquidator, trustee, executor, administrator, arbitrator, or receiver, but shall include the following: financial management planning and financial policy determination, capital structure planning and advice regarding rising finance, working capital management, preparing project report and feasibility study, preparing cash budget, cash flow statement, profitability statement, statement of sources and application of fund, budgeting including capital budget and revenue budget, inventory management, material handling and storage, market research and demand studies, price fixation and other management decision making, management accounting system, cost control and value analysis, control methods and management information and reporting, personnel recruitment and selection, setting up executive incentive plans, wage incentive plan, management and operational audit, valuation of shares and business, and advice regarding the amalgamation, merger, and acquisition acting as registered value under the Companies Act 2013, read with the Companies Registered Value and Valuation Rule 2017, incorporate pursuant to decision of Council at its 388 meeting. Business policy, corporate planning, organization development, growth and diversification, organization structure and behavior development of human resource, including design and conduct of a training program, work study, job description, job evaluation, and evaluation of workload. System analysis and design and computer related service, including the section of hardware and development of software in all the areas of service which can otherwise be rendered by the chartered accountant in practice, and also to carry out any other professional service relating to EDP. Acting as advisor or consultant to an issue including such a matter as drafting of prospectus and memorandum containing the salient features of prospectus, drafting and filling of listing agreements and completing formalities with the stock exchange register of companies and SEBI. Preparation of publicity budget advice regarding arrangement for selection of aid media centers for holding conferences of brokers, investors, banker to issue collection centers, broker to issue underwriters, and the underwriting arrangement, distribution of publicity and issue material, including application form, prospectus, and brokers, and deciding on the quantum of issue material. In doing so, the relevant provision of the Code of Ethics must be kept in mind. Advice regarding the selection of various agencies connected with issue, namely registrars, to issue printers and advertising agency. Advice on the post-issue activity follow-up steps, which include a listing of instrument and dispatch of certificate and refunds with the various agency connected with the work. For removal of doubt, it is hereby clarified that the activity of broking, underwriting, and portfolio management are not permitted. Investment counseling in respect of securities as defined in Security Contract Regulation Act 1956 and other financial instruments. In doing so, the relevant provision of Code of Ethics must be kept in mind. Acting as registrar to an issue or for transfer of shares securities. In doing so, the relevant provision of Code of Ethics must be kept in mind. Quality audit, environment audit, energy audit, acting as recovery consultant in the banking sector. Insurance Financial Advisory Service under the Insurance Regulatory and Development Authority Act 1999, including the insurance brokerage. Acting as insolvency professional in terms of insolvency and bankruptcy court, those are SOLA Incorporated, pursuant to decision of Council at its 362 meeting. Administrative Service Incorporated, pursuant to decision of Council at its 388 meeting. Administrative services involving assisting clients with their routine or mechanical tasks within the normal course of operation. Such a service require little to no professional judgment and are clerical in nature. Then comes what are the example of administrative services include. कौन से examples है? What are the examples of administrative services include word processing services, preparing administrative or statutory forms for client approval, submitting such forms as instructed by the client, monitoring statutory filing dates and advising an audit client of those dates. For example, the function of a GST practitioner as specified in the Rule 83(8) of the Central Goods and Service Tax Rules 2017 furnish the details of outward and inward supply, furnish monthly, quarterly, annual or final return, make deposit for credit into the electronic cash ledger, file a claim for refund, file an application for amendment or cancellation of registration, furnish information for generation of e-bill, furnish detail of challan in Form GST ITC 04. File an application for amendment or cancellation of enrollment under Rule 58 and file an intimation to pay tax under the composition scheme or withdraw from the said scheme. Pursuant to Section 2, Clause 2 of the Chartered Accountant Act 1949, read with Regulation 191 of the Chartered Accountant Regulation 1988, a member shall be deemed to be in practice if he, in his professional capacity and neither in his personal capacity nor in his capacity as an employee, act as a liquidator, trustee, executor, administrator, arbitrator, receiver, advisor, or representative of costing, financial, or taxation matters, or take up an appointment made by the central government or a state government or a court of law or any other legal authority, or act as a secretary, unless his employment is on a salary cum full-time basis. It is necessary to note that a person is deemed to be in practice not only when he is actually engaged in the practice of accountancy, but also when he offers to render accounting service, whether or not he is in fact does so. In other words, the act of setting up of an establishment offering to perform accounting service would tend to amount to being in a practice even though no client has been served. It may also be noted that a member of the institute is deemed to be in practice during the period he renders service with armed forces. The above provision need to be correlated with the provision of Section 144 of the Companies Act, which prohibits an order the company from rendering certain service directly or indirectly to the company or its holding or its subsidiary. Section 144 of the Companies Act 2013 prescribes certain service which is not to be rendered by the auditor. An auditor appointed under this act shall provide the company only such other services as are approved by the Board of Directors or the Audit Committee as the case may be, but which shall not include any of the following service, whether such services are rendered directly or indirectly to the company or its holding or subsidiary company, namely accounting and bookkeeping, internal audit, design and implementation of any financial information system, actuarial services, investment advisory service, investment banking service, rendering of outsourced financial service, management service, or any other kind of service as may be prescribed. Accounting and bookkeeping service, internal audit, design and implementation of any financial information system, actuarial service, इन्वेस्टमेंट. तो इसको बेसिकली हमने इंटरमीडिएट पे भी पढ़ा था, मैंने इसे लर्न किया था, टीचर ने बताया था कॉल्ड एज अ अकेडमिक. अकेडमिक मीन्स ए स्टैंड्स फॉर अकाउंटिंग एंड बुक कीपिंग सर्विस. सी में था कि कैरी आउट एनी अदर सर्विस एज मे बी प्रिस्क्राइब. देन अगेन ए से था एक्चुरियल सर्विस. देन ACA. डी से था डिजाइन एंड इम्प्लीमेंटेशन ऑफ एनी फाइनेंशियल इंफॉर्मेशन सिस्टम. फिर ई से था अगर वो इंगेज हो इन इन्वेस्टमेंट बैंकिंग सर्विस या फिर इन्वेस्टमेंट एडवाइजरी सर्विस. एम से उसमें था मैनेजमेंट सर्विस. और आई से रेंडरिंग ऑफ आउटसोर्स फाइनेंशियल सर्विस, ये हो गया है इन्वेस्टमेंट एडवाइजरी और ऐसा करके कुछ था. Code. Certain service not to be rendered by the auditor as per section 144 of the Companies Act 2013. Mr. A, practicing chartered accountant, agreed to select and recruit personnel, conduct training programs for on behalf of a client where he is not providing any assurance service. Is this a professional misconduct? Mr. A एक practicing chartered accountant है. They agree to select and recruit personnel. वो एग्री हो जाते हैं कि वो सेलेक्ट करेंगे, रिक्रूट करेंगे पर्सोनल को, कंडक्ट ट्रेनिंग प्रोग्राम्स फॉर ऑन बिहाफ ऑफ अ क्लाइंट विच इज नॉट प्रोवाइडिंग any assurance service. Is this a professional misconduct? Provide career management consultancy and other service of the Chartered Accountant Act 1949. A member of the institute shall be deemed to be in practice when individually or in partnership with Chartered Accountant in practice. He is in a consideration of remuneration receive render such a service as in the opinion of council or may be rendered by the Chartered Accountant in practice. Pursuant to section this above, the council has passed a resolution permitting a Chartered Accountant in practice to render an entire range of management consultancy and other service. The definition of expression management consultancy and other service includes personal recruitment and selecting personnel. Recruitment and selection includes development of human resources, including designing and conduct of training programs, work study, job description, job evaluation, and evaluation of workloads. Therefore, Mr. A is not guilty of professional misconduct. नहीं है. Providing management consultancy service. क्या management consultancy service इसमें आ रहा था? management service तो आ रहा था. Providing management consultancy and other service. Under section 2 clause this of chartered accountant, a member of the institute shall be deemed to be in practice when individually or in a partnership with a chartered accountant in practice. He is in consideration of remuneration received to be received under such other service as in the opinion of council and may be rendered by chartered accountant in practice. Pursuant to this section above, the council has passed a resolution permitting a chartered accountant in practice to render entire range of management consultancy and other service. जो मैनेजमेंट कंसल्टेंसी है उसमें इंक्लूड होता है पर्सोनल रिक्रूटमेंट एंड सिलेक्शन. Include development of human resource, including designing and conduct of training program, work study, job description, job evaluation, and evaluation of workload. So therefore, Mr. A is not guilty of professional misconduct. नहीं है. What we are supposed not to render certain service, these are the services. तब इसमें क्या बोल रहा है मिस्टर ए जो है वो ये मैनेजमेंट कंसल्टेंसी की सर्विस दे रहा है तो क्या चल जाएगा? Companies not to engage in accounting. Section 25 of the Chartered Accountant Act 1949 provided no company whether incorporated in India or elsewhere shall practice as chartered accountant. Here the term company shall include any limited liability partnership which has a company and its partner for the purpose of this section. If any company contravene this provision, then without prejudice to any other proceedings which may be taken against the company, every director, manager, secretary and any other officer thereof who is knowingly a party to such a contravention shall be punishable with a fine which may extend to first conviction of 1000 or subsequent conviction of 5000. In addition, as per Section 141, subsection 2 of the Companies Act 2013, where a firm including a limited liability partnership is appointed as an auditor of a company, then only the partner who are chartered accountant shall be authorized to act and sign on behalf of the firm. Though the LLP are allowed to be appointed as auditor in accordance with the Companies Act, however, it cannot be engaged into practice if it has a company at its partner as per the Chartered Accountant Act 1949. Therefore, it cannot be inferred that LLP not having any company at its partner can be engaged into the practice and thus take audit assignment. Member in practice prohibited from using a designation other than Chartered Accountant. Members of the institute are now permitted to use the word CA as a prefix before their name, irrespective of the fact they are in practice or not. Under Section 7 of Chartered Accountant Act 1949, a member in practice cannot use any designation other than the chartered accountant, nor he can use any other description, whether in addition thereto or in submission thereof. But a member who is not in practice and does not use the designation of chartered accountant may use any other description. Nevertheless, a member in practice may use any other letters of description indicating shall be deemed to be prohibit any such a person from adding any such other description or letter to his name. If he entitled thereto to membership of such other institute of accountancy, whether in India or elsewhere, may be recognized this behalf by the council or any other qualification that he may possess to prohibit a firm, all the partners of which the member of the institute in practice from being known by its firm name as chartered accountant. Merchant banker advisor to an issue. The member may apply for and obtain registration as a category 4 merchant banker under the SEBI rules and regulation and act as advisor consultant to an issue. Inclined companies offer document and advertisement regarding the capital issue, name and address of chartered accountant or firm of chartered accountant acting as advisor or consultant to the issue be indicated under the caption advisor consultant to the issue. However, the name and address of such chartered accountant and firm of chartered accountant should not appear prominently. Directors of a company, members or political party position in clubs, the member of the institute who are also the director in companies, member of political parties or chartered accountant sales in political party holding different position in clubs or other organization are not permitted to mention this position, as this would be violated of the provision of section 7 of the act. Member who are also the cost accountant, though the member cannot designate himself as a cost accountant, he can use the letter ACMA or FCMA after his name when he is a member of that institute. नेम के बाद पहले permission to mention qualification of certain institutions. The members are permitted to mention membership of foreign institute of accountancy which has been recognized by the council through memorandum or memorandum of understanding MOU, mutual recognition agreement MRA with the said institute. Other qualification of the members. With regard to the other qualification of member, which he is permitted to mention the following observation of the Supreme Court. The Institute of Chartered Financial CFA, that is the Chartered Financial Analyst of India ICFAI versus Council of the Institute of Chartered Accountant of India dated 16 May 2007 are relevant. The expression any other qualification that he may possess therefore must be read as a qualification other than conferred upon the member by the Institute of Accountancy. Such a qualification of accountancy may be conferred even by other institute, but as noticed hereby, as exemption has been granted by reason of resolution of the institute in relation to the Institute of Cost and Work Accounting. Furthermore, a degree conferred by any university also is subject to exemption from the rigor of the provision of Section 7 of the Act. There cannot therefore be any doubt whatsoever that the other qualification would mean a qualification other than granted by the Institute of Accountancy, subject of course to recognition thereof by the institute. For example, though a member cannot designate himself as a cost accountant, he can use the letter ACMA, FCMA after his name when he is a member of the institute. It is improper for a chartered accountant to state on his professional document that he is income tax consultant, cost accountant, company secretary, cost consultant or management consultant. Members are allowed to appear before the various authority including company law board, income tax appellate tribunal, sales tax tribunal where the law has permitted the same so far as designation corporate lawyer is concerned. The council was of the view that as per the existing provision of a law, a chartered accountant in practice is not entitled to use the designation corporate lawyer. Further, the member are not permitted to use the initial CPA standing for Certified Public Accountant on their visiting cards. Member of the institute in practice who are otherwise eligible may also practice as a company secretary or cost accountant. Such a member, however, not use designation of the aforesaid institute simultaneously with the designation chartered accountant. Maintenance of branch offices. In terms of Section 27 of the Act, if a chartered accountant in practice or a firm of chartered accountant has more than one office in India, each one of the such office should be in a separate charge of member of institute. Failure on the part of member or a firm to have a member in a charge of its branch and a separate member in case of the branches where there is a more than one would constitute professional misconduct. However, exemption has been given to members practicing in hill areas subject to certain conditions, the Condition Act. Such members and firms be allowed to open a temporary office in a city in a place for a limited period not exceeding 3 months in a year. The regular office need not to be closed during the period and all the correspondence can continue to be made at the regular office. The name board of the firm in the temporary office should not be displayed at the times other than the period of such office is permitted to function as above. The temporary office should not be mentioned in the letterhead, visiting cards, or any other document as a place of business of the member of firm. Before commencement of every winter, it shall be obligatory on the member and firm to inform the institute that it is opening the temporary office from a particular date, and after the office is closed at the expiry of the period or permission, an intimation to that effect should also be sent to the office of the institute by registered post. Above condition apply to any additional office situated at a place beyond 50 km from the municipal limit in which any office is situated. It is necessary to mention the chartered accountant in charge of the branch of another firm should be associated with him or with the firm either as a partner or as the paid assistant. If he is a paid assistant, he must be in a whole-time employment with him. The requirement of Section 27 in this regard to a member being in charge of an office of a chartered accountant in practice or a firm of such a chartered accountant shall be satisfied only if the member is actively associated with such office. Such association shall be deemed to exist if the member resides in a place where the office is situated for a period of not less than 182 days in a year, or if he attends the said office for a period of not less than 182 days in a year, or in such other circumstances as in the opinion of executive committee establish such active association. However, a member can be in charge of two offices if they are located in one and the same accommodation. In the context, some of the council decisions are as follows. With regard to the use of the name board, there will be no bar to the putting up of a name board in the place of residence of a member with the designation of chartered accountant, provided it is a nameplate or name board of an individual member or note of the firm. Mr. X and Mr. Y, partners of chartered accountant firm, one in charge of head office and another in charge of branch at a distance of 80 km from the municipal limit, puts up a name board of a firm in both premises and also in their respective residence. Putting name board of a firm at a residence, the council of the institute has decided that with regard to the use of name board, there will be no bar of putting up a name board in a place of residence of a member with the designation of chartered accountant, provided it is a nameplate or board of an individual member and note of the firm. In the given case, partner of XY and company put up a name board of the firm in both offices but not in their respective residence. As the chartered accountant are guilty of misconduct, the distance given in the question is not relevant for deciding. The exemption may be granted to a member or a firm of chartered accountant in practice to have a second office without such a second office being under the separate charge of member of the institute, provided the second office is located in the same premises in which the first office is located, and the second office is located in the same city in which the first office is located. For example, city office 1, office 2. The second office is located with a distance of 50 km from the municipal limits of the city in which the first office is located. A member having two offices of this type referred to above shall have to declare which of the two in his main office which would constitute his professional address. Mr. K, chartered accountant, practice as a sole proprietor, has an office in the suburbs of Chennai. Due to increase in the income tax assessment work, he opened another office near the income tax office, which is within the city and at a distance of 30 km from his office in the suburb. For running the new office, he has employed a retired income tax commissioner who is not a chartered accountant. Maintenance of branch office in the same city as per Section 27 of Chartered Accountant Act 1949. If a chartered accountant in practice has more than one office in India, each one of these offices should be in a separate charge of a member of the institute. However, a member can be in charge of two offices if the second office is located in the same premise or in the same city in which the first office is located, or the second office is located within a distance of 50 km from the municipal limit of a city in which the first office is located. In the given case, K Chartered Accountant in practice as a sole proprietor at Chennai has an office in suburbs in Chennai. Due to increase in the work, he has opened another branch within the same city near the income tax office. He also employed a retired income tax commissioner to run the new office, and second office is situated within a distance of 30 km, मतलब within 50 चलेगा तो फिर ये from his office in the suburb. In the view of above provision, there will be no misconduct if Mr. K will be in charge of both the offices. However, he is bound to declare which of the two offices is of the main office. KYC norms for CN in practice. The financial service industry globally is required to obtain information of their client and comply with you. Know your customers. KYC norms. Keeping in mind the highest standards of chartered accountant profession in India, the Council of ICA issues such norms to be observed by the members of the profession who are in practice. In light of this background, the Council of ICA approved the following KYC norms, which are mandatory in nature and shall apply in all assignment pertaining to attestation function. The KYC norm approved by the Council of ICA are given below. Where client is an individual and proprietor, general information, name of the individual, PIN number, Aadhaar card number of the individual, business description, copy of last audited financial statement. Engagement information, types of engagement, where client is a corporate entity, general information, name and address of the entity, business description, name of the parent company in case of subsidiary, copy of last audited financial statement, engagement information, type of engagement, regulatory information, company, PAN number, company identification number, director name and address, director identification number. Where client is a known corporate entity, general information, name and address of entity, copy of PIN number, business description, partner name and address with their PAN, Aadhaar card, DIN, copy of last audited financial statement. Engagement information, type of engagement, chartered accountant in service in accordance with the definition provided under the Code of Ethics. A professional accountant in a service or a chartered accountant in service means a professional accountant employed and engaged in an executive or non-executive capacity in areas such as commerce, industry, service, the public sector, education, the not-for-profit sector, regulatory bodies or professional bodies, or a professional accountant contracted by such entities. What will be the disciplinary procedure? Section 21, 21A, 21B, 21C, 21, 22A, 22C of the Chartered Accountant Act with the Chartered Accountant Procedure of Investigation of Professional and Other Misconduct of Cases Rule 2007 have laid down the following procedure in regard to investigation of misconduct of a member, which have been summarized as under. Flow chart of discipline procedure mechanism, receipt of complaint along with the prescribed fee information against the member of ICI of alleged misconduct. Disciplinary directorate prima facie opinion, guilty, non-guilty, falling in a first schedule, place the matter before the board of discipline. Accepted है, rejected है. अगर accepted है तो conduct inquiry, rejected है then close the matter. Conduct inquiry, found guilty, yes or no, it can reprimand the member, remove name of the member up to a period of 3 months, and impose a fine up to 1 lakh. Any member or director discipline agreed by order of board or disciplinary committee can prefer an appeal within 90 days. Appellate authority, it can confirm, modify or set aside the order, impose, set aside, reduce or enhance the penalty, remit the case to the board of discipline or disciplinary committee for reconsideration, pass such order as the authority think fit. Falling in a second schedule or both, place the matter before disciplinary committee, accepted, rejected, conduct कीजिए आप. आपको क्या करना होगा? What you need to do, that is conducting the inquiry, found guilty. What we need to do, that is accept कीजिए, conduct inquiry, अगर found, अगर if it is guilty, yes or no. It can reprimand the member, remove the name of the member permanently or any duration it thinks fit, impose the fine up to rupees 5 lakh. Not guilty, submit all the information and complaints to board, discipline, accepted, rejected, advise the director discipline to member, investigate, may proceed with the matter that is alleged the first schedule, refer the matter to the disciplinary committee if it is alleged to the second schedule or both. It can confirm, modify, set aside the order, impose, set aside, reduce or enhance the penalty, remit the case to the we can remit the case to the board of discipline or disciplinary committee for reconsideration, pass such order as authority think fit. What are the types of misconduct, professional or other misconduct? For the purpose of this act, the expression professional or other misconduct shall be deemed to include any act or omission on the part of any member of the institute, either in his individual or as a partner or owner of a firm, as mentioned in any of the schedule, but nothing in this section shall be construed to limit or abridge in any way by the power conferred or duty cast on the director discipline under subsection 1 of section 21 to inquire into the conduct of such a member or firm under any other circumstances. A member is liable to disciplinary action under section 21 of the Chartered Accountant Act if he is found guilty of any professional or other misconduct. What is a professional misconduct? Professional misconduct has been defined in part 1, 2 and 3 of the first schedule and part 1 and 2 of the second schedule. A member who is engaged in a profession of accountancy, whether in a practice or in service, should conduct restrict his action in accordance with the provision contained in the respective part of the schedule. If the member is found guilty of any of the act or omission stated in any of the respective part of the schedule, she shall be deemed to be guilty of professional misconduct. Other misconduct has been defined in a part 4 of the first schedule and 3rd of the second schedule. This provision empowers the council to inquire into any misconduct of a member even it does not arise out of his professional work. This is considered necessary because the chartered accountant is expected to maintain the highest standard of integrity even in his personal affairs, and any deviation from this standard even in his non-professional work would expose him to disciplinary action. For example, a member who is found to have forged the will of a relative would be able to disciplinary action even though the forgery may not have been done in the course of his professional duty. Other misconduct would also to conviction by competent court for an offence involving the moral turpitude with the transportation or imprisonment to an offence not of a technical nature committed by the member in his professional capacity. Then comes what are the schedule to the actor. Actor omission which comprise professional misconduct within the meaning of section 22 of the Chartered Accountant Act are defined in two schedules, first schedule and the second schedule. The first schedule is divided into four parts. Part 1 of first schedule deals with misconduct of a member in practice, which would have effect generally of compromising his position as an independent person. Part 2 deals with misconduct of member in service. Part 3 deals with misconduct of members generally, and Part 4 deals with other misconduct in relation to the members of the institute generally. The second schedule is divided into three parts. Part 1 tells misconduct in relation to a member in practice. Part 2 deals with the misconduct of a member generally, and Part 3 deals with other misconduct in relation to members of the institute generally. This is the type of schedule, first schedule, second schedule. Part 1 प्रोफेशनल मिसकंडक्ट इन रिलेशन टू चार्टेड अकाउंटेंट इन प्रैक्टिस पे लगता है, उसमें 12 क्लोज है. क्लोज लर्न करना इज वेरी इंपॉर्टेंट, आई मस्ट से, बिकॉज क्लोज से 2 मार्क्स का एक क्वेश्चन एमसीक्यू में तो आता ही है, उसके अलावा एक डिस्क्रिप्टिव में क्वेश्चन आता ही है, एंड देयर इज नो डाउट अबाउट इट. लास्ट टाइम इन May 24 एग्जामिनेशन में वेटेज जो है इंस्टीट्यूट ने थोड़ा सा ऊपर नीचे कर दिया था इन द प्रोफेशनल एथिक्स, बट वी कैन प्रेडिक्ट इंस्टीट्यूट एक्शन फर्दर. Otherwise, professional ethics is very important, especially this clues parts. Professional misconduct in relation to chartered accountant in practice, number of clauses are 12. Professional misconduct in relation to member of the institute in service, number of clauses is 2. Professional misconduct in relation to members of institute generally, number of clauses is 3. Other misconduct in relation to members of the institute generally, number of clauses is 2. Professional misconduct in relation to chartered accountant in practice, that is number of clauses is 10. Professional misconduct in relation to members of institute generally, number of clauses is 4. Other misconduct in relation to members of institute generally, the number of clauses is 1. The implication of the different clauses in the schedule are discussed below. The first schedule, where the director discipline is of the opinion that the member is guilty of professional misconduct or other misconduct mentioned in the first schedule, he shall place the matter before the board of discipline. Professional misconduct in relation to the chartered accountant in practice or chartered accountant in practice is deemed to be guilty of professional misconduct if he, clause 1, allow any person to practice in his name as a chartered accountant unless such a person is also a chartered accountant in practice or is in a partnership or employed by him. Who can be allowed to be practiced in a CA's name? Non-chartered accountant not allowed. Chartered accountant in practice, partner allowed, employee allowed, and other not allowed. The above clause is intended to safeguard the public against unqualified accountant practicing under the cover of qualified accountants. It ensures that the work of accountant will be carried out by a chartered accountant who may be his partner or his employee and would work under his control or supervision. Mr. C, chartered accountant in practice, allow his brother-in-law Mr. P, who is not a chartered accountant, to practice in the name of CA. He also allows CAT, who is employee in his firm, to practice in the name, whether C is correct in allowing his brother-in-law Mr. P and CAT allowing his firm to practice in his name. Allowing to practice in a chartered accountant name as per this Part 1 of the first schedule of the Chartered Accountant 1940. A chartered accountant in practice is deemed to be guilty of professional misconduct if we allow any person to practice in his name as a chartered accountant unless such a person is also chartered accountant in practice or in the partnership with or employed by him. In the given case, Mr. C, a chartered accountant who is in practice, allow a non-chartered accountant, his brother-in-law, Mr. C, to practice in the name of CA. C is not correct in view of Part 1 of Clause 1 of Part 1 of Schedule Part 1 of the first schedule. However, he can allow CA2, who is employee in his firm, to practice in his name. The CA will be held guilty of professional misconduct for allowing Mr. P, who is not a chartered accountant, to practice in his name as a chartered accountant as per the clause Part 1 of the first schedule. Then comes next, Satarega, and so on. But we are not covering the things further because already 1 hour we have spent. We just barely read the things and trying to getting कि कितना आ रहा है कितना नहीं, and that's it. Because उसके बाद when we will sit for the learning purpose, we will learn each and every clause. In this one, we are only trying to cover the things from study material. So hope that you may get this point as well. Alright, bye from my side and meet you, hope so, in the next one.